Do you know what your landlord cannot do legally? Welcome, folks, to a conversation that's often swept under the rug. In this video, we're going to break down the things that are off limits for landlords. This isn't just for tenants who want to protect themselves, but also for landlords who value fairness and legality. Understanding these boundaries can help foster a healthy landlord-tenant relationship. So, stick around to know your rights and to ensure that you are not being taken advantage of. Firstly, your landlord cannot harass you. This is a fundamental tenet of rental agreements, yet it is often overlooked or misunderstood. Harassment by a landlord is not just a nuisance, it's illegal. It can take on many forms, some of which you might not immediately recognize as harassment. For instance, has your landlord ever changed the locks on you without notice or justifiable cause? Or perhaps they've turned off your utilities in an attempt to make you uncomfortable in your own home. These actions are not only disruptive, they are also illegal. Another form of harassment could be consistent, unreasonably frequent inspections of your property. While landlords do have the right to inspect their property, they must give you reasonable notice and must not abuse this right to the point of harassment. Threats, intimidation, or any other behavior that interferes with your right to enjoy your home quietly and peacefully also fall under the umbrella of harassment. A landlord's role is to provide a safe and habitable living environment, not to make your life miserable. If you find yourself dealing with these or similar issues, it's important to know that you're not helpless. Document everything, seek legal advice, and remember, you have rights. Harassment by a landlord is not something that you should have to tolerate. So remember, harassment from your landlord is illegal, and you have the right to take action if it occurs. Secondly, your landlord cannot illegally raise your rent. Now let's sink our teeth into the nitty-gritty of rent increases. The laws surrounding this can be a bit complex, but we're here to break it down for you. First off, the frequency of rent increases isn't set in stone across the board. It varies by jurisdiction, but generally a landlord cannot hike up your rent willy-nilly. Usually they can only do so once a year, and that's after your initial lease term has ended. So if you've signed a one-year lease, breathe easy. Your rent should remain the same for that period. Now, on to the notice period. The general rule of thumb is that landlords need to give you adequate heads up before they increase your rent. This typically ranges from 30 to 60 days. This gives you ample time to decide whether you're okay with the new rent or if it's time to start looking for a new place. But what if your landlord raises your rent out of the blue, especially after a heated disagreement? Well, that's a big no-no. This could be seen as retaliatory rent increase, which is illegal. Your landlord can't use a rent hike as a weapon to punish you for asserting your rights as a tenant, like asking for necessary repairs or reporting code violations. However, there's a catch. Proving a rent increase is retaliatory can be a bit tricky. You'd have to demonstrate that the rent hike happened shortly after you complained or took action, and that there's no other plausible reason for the increase. In conclusion, while landlords do have the right to increase rent, they can't do so in a way that's unfair or retaliatory. They need to follow legal guidelines, which includes giving sufficient notice and sticking to allowable frequency. Always remember to check local regulations as they may differ, but generally a landlord cannot just raise your rent without proper notice and reason. Thirdly, your landlord cannot discriminate against you. Now, let's dive into the specifics of this crucial point. Discrimination, in this context, refers to any unjust treatment based on certain characteristics such as race, religion, national origin, gender, disability, and family status. The Fair Housing Act, an essential piece of legislation in the United States, was enacted in 1968 to prevent such discrimination. This act makes it illegal for landlords to favor or disfavor tenants based on these protected categories. For example, a landlord cannot refuse to rent to someone because of their race or religion, nor can they charge higher rent or provide less favorable lease terms based on these factors. The Fair Housing Act covers a broad spectrum. It's not just about race or religion, it also protects tenants based on their national origin. This means a landlord can't treat you differently because you're from another country or because of your accent. It's about gender too. Whether you're a man or a woman, you have the right to fair treatment. It also includes disability. If you're a person with a disability, landlords are required to make reasonable accommodations to ensure you can fully use and enjoy your home. They cannot refuse to make these accommodations or charge you for them. And let's not forget about family status. If you're a parent, whether single or married, or if you're pregnant, a landlord can't refuse to rent to you just because you have kids. The act also protects you from discrimination if you're planning to adopt or are in the process of securing custody of any minor. So remember, as a tenant, you have rights. Discrimination, whether subtle or overt, is illegal. You are entitled to fair and equal housing opportunities, regardless of your race, religion, national origin, gender, disability, or family status. If you feel you've been discriminated against, don't hesitate to seek legal advice and protect your rights. Discrimination is illegal, and you have the right to a fair and equal housing opportunity. Fourthly, your landlord cannot evict you without a court order. This is a key point to remember when it comes to your rights as a tenant. The eviction process is one that is wrapped up in legalities and must be carried out in a very specific, lawful manner. Now, we've all heard the horror stories, haven't we? A landlord showing up in the dead of night, throwing belongings on the street, changing locks. These actions, my friends, are not just unethical, but they are also illegal. A landlord does not have the authority to remove a tenant from their home without a court order. Let's delve into this a bit more. The eviction process begins with the landlord providing the tenant with a written notice. This notice should outline the reasons for eviction, whether it's non-payment of rent, violation of lease terms, or something else. The tenant then has a specified period to respond or rectify the stated issue. Here's where the court comes in. If the tenant does not comply, the landlord can then go to court and file for an eviction order. The court then reviews the case, and if they agree with the landlord, they will issue an eviction order. Only then can the landlord legally remove the tenant from the property. Bear in mind that this process varies slightly from place to place, but the basic principle remains the same. It's important to know your local laws and rights. But what if your landlord doesn't follow this process? What if they try to evict you without a court order? You have the right to fight back. You can seek legal advice, contact your local tenants' rights organization, or go to court yourself. In the end, remember this. Your home is your sanctuary. No one, not even your landlord, can take that away from you without due process. Being evicted without a court order is illegal, and you have the right to fight an unlawful eviction. Lastly, your landlord cannot make security deposit deductions for normal wear and tear. Now, you might be wondering, what exactly does normal wear and tear mean? Well, it refers to the inevitable physical decline of the property due to regular use. This could be things like faded paint, worn-out carpet, or even minor scuffs on the wall. These are all considered normal and expected, and your landlord cannot dip into your security deposit to cover these costs. On the other hand, damages that go beyond normal wear and tear are a different story. If you've punched a hole in the wall, broken a window, or caused any other significant damage, your landlord has the right to make deductions from your security deposit to cover the cost of repairs. It's important to understand this distinction because it can help you protect your rights as a tenant. If you ever find yourself in a situation where your landlord is trying to withhold your security deposit for normal wear and tear, don't hesitate to stand your ground. In some cases, it might be beneficial to take before and after pictures of the property to provide a clear record of its condition. This can serve as evidence if there's ever a dispute about what constitutes normal wear and tear versus damage. Remember, your security deposit is your money and should be returned to you, less any lawful deductions. To wrap up, knowing your rights as a tenant can save you from a lot of trouble. We've touched on the importance of understanding your protection against harassment, unlawful rent increases, discrimination, unlawful eviction, and unjustified security deposit deductions. It's crucial to delve deeper into your local regulations and be prepared to stand your ground. Knowledge is your best defense. Stay informed, stay safe, and remember, you have rights as a tenant. Thank you for watching.